Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back with the Truth Attack. Okay, so let's just get right into this. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating. So, if you enjoy the shows, the information, the revelations, the lectures, the discussions, the guests, and the hosts on the other shows on the network, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website and get signed up as a subscribing member, even if it's as little as $15, $20 a month. Every membership helps, and we do need your support to keep the broadcast network operating and the information coming. So, there you have it. And if you want to get fully informed on the maladministration of the personal income tax by the Internal Revenue Service, the DOJ, and the lower federal courts for the last 75 years, basically since World War II, head on over to taxfreedom.com and start reading. Get educated, because the Supreme Court has rolled it back and the media isn't telling anyone what they've done. And what they've done is destroy the IRS and DOJ's fraudulent enforcement of the tax and the lower court's ability to continue upholding that fraudulent and communistic enforcement. So we're going to get back into that in a bit, because last week I was reading from the petition we've written to the Supreme Court to end the fraudulent, maladministered system, and I'm going to pick that up again in just a bit. First, and if you know anyone who needs help answering IRS correspondence or answering the DOJ in court, you send them over to irszoom.com, where they can get help answering IRS letters for just $50 a letter or less, and they can get help answering the Department of Justice in court, challenging their prosecution of a tax law that the Supreme Court says does not exist, which is what they've been doing for 75 years. So, first, let's talk a little bit about what's going on in the country. The partial government shutdown goes on as the Democrats refused to fund the government until illegal aliens are allowed to vote in national elections and keep the Democrats in power. Oh, isn't that wonderful? And of course, that's the only reason, isn't it, for having no voter ID or no requirement to identify oneself in order to vote, which is what all the liberal states have done. They ran in 15 million illegal aliens under Biden, pushed them all into Democrat liberal states, and registered them all to vote so they wouldn't lose seats in the Congress, electoral votes in the Electoral College, or representative standing in their own states. So the Democrats are clearly intending to import a new voter base that they have obviously prioritized over existing minority voter bases, i.e. the blacks and Hispanics, who have been thrown under the bus by the Democrat Party over the last 4 years in order to usher in and prioritize their spending on illegal aliens and getting their votes. And that's what it's all about, and that's what the Democrats are trying to do. Pervert the American government to turn it into a global socialist ghetto. Take a look at what's happening in the places where the Democrats have been running the cities for 50 years. San Francisco, LA, New York, Baltimore, Newark, St. Louis. It goes Chicago. It goes on and on and on. I do not understand why black folks are still voting for Democrats. They have done nothing but screw the black population for 60 years. They've turned them into dependent near slaves. They just don't make them work. They just make them sit with bad schools, bad housing, bad job opportunities. And the Democrats keep voting for it. The black population keeps voting for the Democrats. It's just simply mind-boggling. And they appear to be oblivious to the fact that it was the Democrats that owned the slaves, owned the slave plantations, owned the slave ships, conducted the slave trade, bought and sold the slaves, resisted the 13th, the 14th, the 15th Amendments, came up with Jim Crow, KKK, segregation. It was all Democrat policy. Lincoln and the Republican Party was created on the fundamental plank basis of eliminating slavery. And it was the Republicans that opposed the Jim Crow laws. It was the Republicans that passed the amendments. It was the Republicans that put the civil rights laws in place in the 60s, which the Democrats opposed. So why any black person who wasn't brain dead is still voting for Democrats, I'd like one of them to explain that to me. How is that possible? So, anyway. Okay, what else is going on? Well, we got the Olympics going on, which are making for a nice distraction. Today, a couple hours ago, the U.S. women's hockey team won the gold medal, defeating Canada in overtime. And this is one of the sports that's been pretty good, actually really good as of late. Most of the men's games all were settled in overtime, and the women's gold medal and bronze medal games were both settled in overtime. I think it was Switzerland or Sweden that won the bronze medal. Canada, of course, won the silver. They were ahead. They were ahead 1-0 for nearly the entire game. The first period was a 0-0. The Canadians scored early in the second and then held a 1-0 lead all the way to the end of the game, when with 2 minutes and 9 seconds left, the U.S. scored to tie it up. And in the Olympics, they don't play overtime as in regular hockey, where they have a whole period of 5-on-5, and then they go to a shootout if it's still tied. In the Olympics, they go to a 3-on-3 with no intermission. And it doesn't last long with 3-on-3. I think both of the men's games were settled within 3 minutes, and the women's game today was settled when 2 minutes in, one of the U.S. players broke in front of the net and pushed it through. So that was kind of exciting and fulfilling for the U.S. women's hockey team. The men are in the quarterfinals, I believe, and playing again to get to the gold medal game against what will inevitably be, probably, the Canadians. So there's a little bit of that, what's going on. That's fun. Okay, so now let's go ahead and get back to what we were doing last week when I was reading from the petition we've written to the Supreme Court. And let's review where we were at, because I got through the first 4 points, issues. And what we're doing here is we're building the case point by point to expose the fraudulent operations in the lower courts. Because while the tax is constitutional as an indirect tax, that is not what the IRS has been doing. That is not what the DOJ has been arguing. That is not what the lower circuit courts have been holding. They have all been holding that the income tax is a direct tax without limitation under the 16th Amendment, and that there is no limitation to its applicability, limited as an indirect tax to only impose duty and excise taxable activities and transactions, which do not include any transactions of the American people conducted in the 50 states by right, neither by the right to work or the right to acquire property. Doesn't exist. Never has, never did. It's all been a fraud. So let's look at the 4 points we covered last week. 1, in Moore et Ux v. United States, 602 U.S. 572, 2024, This Supreme Court held that the federal personal income tax is an indirect tax. Under authority of Article 1, Section 8, Clause 1 of the U.S. Constitution. So here we're citing the Supreme Court's determination in Moore just a year and a half ago that income taxes are indirect taxes, which directly contradicts what the courts and the government have been arguing since 1955. Directly contradicts it from the Supreme Court. It's about time. Why they let this go on for 70 years, fraudulently, along with Roe v. Wade, Chevron regulatory deference, and affirmative action, well, who knows, right? Liberal decisions nearly destroyed the United States, and thank God this court is rolling them back. Let's hope they finish the job and roll this back too, because they've laid all the work and the rulings have already been made. 1. Income tax is an indirect tax under authority of Article 1, Section 8, Clause 1. 2. In Moore, the court held that all direct taxes must be apportioned to the several states for payment in proportion to the last census as required under the Constitution by Article 1, Section 2, Clause 3, and Article 1, Section 9, Clause 4. So here the Supreme Court is telling the IRS, the DOJ, and the lower courts that direct taxes are apportioned to the states. That means their fraudulent operation of enforcing the tax as a direct tax without limitation can no longer be continued. It's a fraud. Direct taxes have to be apportioned to the several states. They cannot be demanded from the individual Americans, as they have been doing for 75 years. Third point, the federal personal income tax, obviously, is not a non-apportioned direct tax on income under the 16th Amendment. And that's the conclusion you have to arrive at based on 1 and 2. It's not a non-apportioned direct tax. It's an indirect tax, and direct taxes have to be apportioned. This is just logically stepping through the court's rulings. 4. The case record shows the district court erroneously claimed a subject matter jurisdiction under the 16th Amendment to enforce a non-apportioned direct tax on income against the individual person of the defendant. So the court claimed jurisdiction to enforce a direct tax. They did it under 2 decisions, one from the circuit court, one from the district court. The circuit court, it's the Collins decision that the 10th Circuit uses to say it's a non-apportioned direct tax, which they've used since 1980 to enforce communism, not constitutional taxation. They should be ashamed of themselves. Okay, so I think that takes us up to point 5, which is where we were when we laid off last week. And point 5 is issue 5. Let's roll back here to it, and then we'll roll down to it. Under the Constitution and more, the federal courts lack the subject matter jurisdiction to conduct tax trials of individuals, to enforce against them the payment of a non-apportioned direct tax on their own income under an alleged authority of the 16th Amendment to tax directly and without limitation. The federal courts lack the subject matter jurisdiction to conduct the trials in the manner that they have. Okay, let's bounce down to page 8 and we'll read number 5 because I think that's where we left off. Isn't here at 5, where is it? It must be 7, issue 7. Okay, let's pick up where we left off. Under Moore, the district court fatally lacked the subject matter jurisdiction to enforce against the individual defendant criminal charges based on an alleged unavoidable, unlimited, non-apportioned direct tax on his own income, which may only be enforced against the several states under the Supreme Court's decision in Moore. We'll be back in 5 with more on Moore. Okay, this is Thomas Freed on the Liberty Works Radio Network. Let's just get right back into this. We were reading from the petition to the Supreme Court. We're up to issue 5, where we argue under the Constitution and more, the federal courts lack the subject matter jurisdiction necessary to conduct tax trials to enforce a non-apportioned direct tax against individuals. This is based on the Supreme Court's 2 rulings and more, that income taxes are indirect taxes and that all direct taxes must be apportioned to the several states and thus cannot be enforced against individuals, as the IRS, DOJ, and the lower courts have unconstitutionally been doing since World War II. So let's pick it up. The jurisdictional error is fatal to both the criminal conviction of the defendant in this case and to the previous civil judgment against him in 2017, out of which count 3 of the criminal case arises. Because under the Constitution, the income tax is an indirect tax under authority of Article 1, Section 8, Clause 1 of the Constitution. And then we cite Flint v. Stone Tracy. Quote, duties and imposts are terms commonly applied to levies made by governments on the importation or exportation of commodities. Excises are taxes laid upon the manufacture, sale, or consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. The requirement to pay such taxes involves the exercise of the privilege, and if business is not done in the manner described, no tax is payable. It is the privilege which is the subject of the tax, and not the mere buying, selling, or handling of goods, or earning of money, or even of having income. It's the privilege, not the earning. It's the privilege, but citizens don't earn by privilege. They have a right to work, not a corporate privilege under which everything the corporation earns is made through the privilege of incorporation. It's all taxable. None of that is true for citizens. That quotes Flint v. Stone Tracy, 220 U.S. 105, 1911. I might add, Flint v. Stone Tracy is constitutional law, cited over 600 times in the last 100 years by every court in the land as establishing the limit of the scope of indirect taxation. Okay, next we also quote Stanton v. Baltic Mining. By the previous ruling, which was Bruce Shaber, it was settled that the provisions of the 16th Amendment conferred no new power of taxation, but simply prohibited the complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belonged. So the 16th Amendment didn't declare the income tax to be a direct tax under the 16th Amendment. It prohibited that declaration by permanently saying it was indirect. The courts reversed that to enforce their socialist, philosophical, communist, really, philosophy on America since World War II, when they got away with it and basically defeated both the Nazis and the Japanese without a whole lot of help. Okay, let's go on. The Utah District Court fatally lacked the subject matter jurisdiction to conduct both the civil trial in 2017 and the criminal trial in 2024 to enforce claims for a non-apportioned direct tax on income. The lower courts have erroneously and prejudicially ignored this fatal defect and constitutional error that is plainly and clearly evidenced in this case's records in both the civil and criminal actions against the defendant regarding the falsely claimed subject matter of the district court to enforce a direct tax on income against an individual defendant. And then we cite a case. Jurisdiction is fundamental, and a judgment rendered by a court that does not have jurisdiction to hear the action is void ab initio. In RE application of Wyatt, RE Cavett. Courts are constituted by authority, and they cannot go beyond that power delegated to them. If they act beyond that authority, and certainly in contravention of it, their judgment and orders are regarded as nullities. They are voidable. They are not voidable, but simply void. And this even prior to reversal. Williamson v. Berry from 1850. Additional precedents addressing the court's requirement to fully establish on the record before trial the specific subject matter jurisdiction of the court taken and the consequences incurred by a court acting without that required jurisdiction are easily found. And we cite them in the appendix under a footnote here. The district court erroneously claimed jurisdiction under Collins' beliefs in the 16th Amendment to tax the defendant's income directly and without limitation. It is now clear under Moore that the court's jurisdictional claim was erroneous because the court lacked subject matter jurisdiction to enforce an unlimited direct tax against the individual defendant. Issue 6. The court erred in its judgment by stating, since ratification of the 16th Amendment, whether an income tax is a direct tax or an indirect tax is immaterial. It further erred in asserting that it is beyond dispute that Congress has the power to tax the income of individuals, as Article 1, Section 8, Clause 1 does not authorize any such direct and unavoidable taxation of the citizens in the 50 states. Okay, on page 6 of the order and judgment, the appellate court writes, since ratification of the 16th Amendment, whether an income tax is a direct tax or indirect tax is immaterial. This is plain error, because indirect taxes are avoidable by definition, while direct taxes are unavoidable and must be apportioned to the several states for payment, which absolutely is material to the ability of the courts to lawfully take a granted subject matter jurisdiction over tax trials of individuals to enforce the specific type of tax alleged, owed, and or evaded, defeated. It is clear from this erroneous immaterial assertion that the Circuit Court failed to acknowledge and abide by both the constitutional limitations imposed on all direct taxation and the doctrine of stare decisis under Moore regarding the Supreme Court's decisions therein. The appeals court erred in this immaterial holding because, one, the tax is indirect, not direct. Two, a direct assessment of tax cannot be enforced against an individual person like the defendant because, three, all direct taxes must be apportioned to the several states for payment. More supra, citing the Constitution. Therefore, it is very much material whether or not the federal personal income tax is assessed and enforced as a direct tax or an indirect tax, because this court holds in Moore that all direct taxes must be apportioned to the several states for payment, and thus no direct tax can be lawfully enforced at trial against an individual, as was unconstitutionally done to the defendant twice, civilly in 2017 and now criminally in 2024. And As an indirect tax, Moore holds that income taxes are under authority of Article 1, Section 8, Clause 1, making the income tax a function of indirect taxation by impost, duty, and/or excise, and not a new power to tax under the 16th Amendment, neither directly nor indirectly. Finally, simply having earnings as alleged quote-unquote gross income is not a valid basis under the Constitution for indirect taxation by impost, duty, or excise, which only tax activities and transactions involving imports and the activity of foreign persons by impost, exported goods, which are taxed by duty, and commodities, licenses, and corporate privileges, which are taxed by excise. Stone Tracy Super. No sources of earnings of the defendant were lawfully subject to any indirect taxation by impost, duty, or excise, and none were factually evidenced at trial, which evidence only established that money was earned by the defendant from sources within America. It did not establish that any indirect impost, duty, or excise tax applied to those domestic earnings earned by the citizen, and thus no lawful indirect tax was ever shown, neither by fact, evidence, or testimony, to be owed by the defendant, sufficient for him to have been found guilty of failing or defeating any legal or constitutional tax. An unconstitutional, unlimited, direct tax on income was wrongfully and erroneously assumed by both the jury and the courts to apply to Cromar's earnings, the defendant's earnings. The jury was misled by the court into erroneously believing that a non-apportioned, unlimited, unavoidable direct tax on income was authorized to be enforced against the defendant under the 16th Amendment simply as a function of his earning money, which appears to be the argument position being erroneously advanced by the lower courts in their orders and judgments sustaining the conviction of the defendant without the jurisdiction to enforce a direct tax against him as an individual defendant, in clear violation of both the Constitution and this court's decisions in Moore. The circuit court order and judgment further erroneously state on page 6 that it is beyond dispute that Congress has the power to tax the income of individuals. United States v. Stillhammer, 10th Circuit, 1983. This proclamation of the circuit court, citing a 10th Circuit decision from 1983, it's the 10th Circuit citing themselves, is obviously erroneous because Stillhammer, like Collins in 1980, is also based in the erroneous assumption that the income tax is a non-apportioned direct tax on all income under the 16th Amendment. Stillhammer is just as invalid after Moore as Collins is. Both are obviously fatally erroneous because they ignore the indirect nature of the tax. Additionally, okay, I think I hear we have a second break coming up. This is Thomas Freed on the Liberty Works Radio Network. We'll be back in 5 with more on Moore and this petition we've written to the Supreme Court, which we're reading from to try and educate people in America on how to approach this in the courts and defeat the fraud that's been perpetrated. Okay, this is Thomas Fried on the Liberty Works Radio Network. Let's just get right back into this. We were reading from the petition to the Supreme Court to end the federal income tax based on what the court ruled in Moore. Okay, let's just pick it up. Additionally, the Circuit Court then incredibly writes in footnote number 4 that Collins was superseded on other grounds by the Paperwork Reduction Act of 1995, as noted in Lewis v. CIR 523 F3D 1272, 10th Circuit, 2008. The Circuit Court, the 10th Circuit Court, says Collins was superseded in 2008 as an applicable precedent. But amazingly, that somehow did not stop the plaintiff or the court from using Collins as the basis for convicting the defendant in this criminal case, nor from relying on it to foreclose on the defendant's home and property in the civil action in 2017-2018. Where the court erroneously held that Collins did authorize a non-apportioned direct tax on income under the 16th Amendment and allowed the ultra-vires foreclosure and sale of the defendant's home and property to force his individual person to pay a direct and unavoidable tax on his own income. But now the Circuit Court says Collins had already been superseded as an authority when it was wrongfully invoked in both of these civil actions, or in the civil action to foreclose and in the criminal action just last year. How can an authority that has been superseded be invoked as the basis for the subject matter jurisdiction over a criminal trial? How is it superseded? Where's the jurisdiction if not under Collins? There's none shown on the record. This is a total fraud. Let's keep reading. If jurisdiction cannot be taken under Collins for lack of a direct tax on income because it's indirect, then the records of both legal actions against the defendant are completely bereft of any showing of a subject matter jurisdiction of the courts that could lawfully be taken. The Circuit Court's errors continue on page 5. As we observed in Collins, efforts to argue that federal jurisdiction does not encompass prosecutions for federal tax evasion have been rejected as either silly or frivolous by a myriad of courts throughout the nation. See also United States v. Hansen, United States v. Gerhard, United States v. Drachenberg, all citing cases from after the year 2000. All based on the wrong interpretation of the Circuit Courts that it's a non-apportioned direct tax. Every single one of these cases they cite, Hansen, Gerhard, Drachenberg, Cooper, they're all error. They're all erroneous. They're just compounding error on error by citing erroneous cases that built on error as proof that there's no error. These judges this is sedition. This is a cover-up. It's disgusting what the 10th Circuit is doing here. Okay, but every single one of these opinions were written after Collins in 1980 and are all erroneously based on the same constitutional error, if not Collins itself, that was made in Collins, the same constitutional error that was made in Collins, i.e., erroneously declaring the alleged creation of an entirely new power to tax income directly and without limitation under the 16th Amendment. Moore exposes the fatal constitutional error of the various circuit courts of appeals who have been erroneously holding since 1980 that the income tax is an unlimited, non-apportioned direct tax under the 16th Amendment. See Appendix 2, where we cite all of the cases from the circuit courts, from the IRS's frivolous positions argument document, which they've been using to ridicule and denigrate people arguing the Constitution in tax cases. Under Moore, all of those lower court decisions are now exposed as fatal constitutional error, because income taxes are indirect taxes under Article 1, Section 8, Clause 1, under the head of excises, duties, and imposts, more supra, and are not direct taxes under the 16th Amendment. The circuit court then tries to explain its error by writing, "We reject this argument for the same reasons we explained in Cromar's civil tax case, when we declined his invitation to delve into the difficult question of the distinction between direct and indirect taxes." And they cite the case. But the distinction between direct and indirect taxes is not really that hard to understand or delve into. So perhaps the Supreme Court should now resolve the circuit court's difficulty in properly applying the Constitution in federal income tax cases, because all of the other U.S. circuits have the same difficulty as the 10th. The Supreme Court explained in Moore that direct taxes are those taxes imposed on persons or property, with the key and essential element of direct tax being that it is unavoidable. The court further held the Constitution requires that direct taxes be apportioned among the states. To be apportioned, direct taxes must be imposed in proportion to the census or enumeration. U.S. Constitution, Article 1, Section 9, Clause 4, see also Section 2, Clause 3, more supra. In other words, direct taxes on persons and property persons or property that are unavoidable must be apportioned among the states. Because income taxes are indirect taxes, they are permitted without apportionment, but they are not permitted to be imposed as a direct tax on all earnings without limitation. And as an indirect tax, they are also not permitted without evidenced subjectivity to some indirect taxation by impost, duty, or excise. Indirect taxation is classically indicated by the ability to either avoid the tax entirely by abstaining from the taxed activity or transactions, which of course is impossible with the direct tax on all sources of earnings necessary to live, or it is indicated to be indirect by a shifting of the burden to pay that is provided by some mechanism within the law that shifts the burden from the pocket of the designated taxpayer and to the pocket of some other person or party from whom the tax was collected. In other words, indirect taxes must be avoidable in some manner and be geographically uniform in their operation and are imposed only on certain federally taxable transactions and activities subject to taxation by impost, duty, and/or excise. The critical element is that indirect taxes are avoidable under law, either by abstaining from the taxed activity or by a statutory shifting of the burden to pay, usually through a tax collection mechanism. It has the collector paying a tax he collected from other parties, so the collector, the liable party, the taxpayer, never actually pays tax out of his own pocket. He just turns over what he's collected from other parties. The same way a sales tax works, the same way the income tax works, with your employer collecting it and turning over what he's collected from you, not paying it out of his own pocket, taking it from your paycheck, and then he turns over what he's collected. That's indirect collection, paid by a collector who doesn't pay the tax out of his own pocket. He collects it from other persons and then is made liable for the collected tax, which has to be paid to the Treasury. These known distinctions between direct and indirect taxation are not that difficult to understand or delve into, because they have already been addressed in long-standing precedent in the Supreme Court. It's not that difficult. This has all been laid out. It cites, ordinarily, all taxes paid primarily by persons who can shift the burden upon someone else or who are under no legal compulsion to pay them are considered indirect taxes. This is from Pollock v. Farmers Loan and Trust, 1895. In 1895, the Supreme Court laid out the difference between direct and indirect, but 120 years later, the 10th Circuit Court has difficulty delving into the issue. How stupid do these people think we are? It's not difficult. It doesn't need to be delved into. Read the goddamn decision from the Supreme Court, you idiots! The Circuit Court also writes on page 6, in this case, as in every federal criminal prosecution, subject matter jurisdiction comes from Title 18, United States Code 3231, Section 3231. That's the beginning and the end of the jurisdictional inquiry. United States v. Tony, 2011. Oh, you mean you don't need the Constitution to establish jurisdiction? You just make it up under statute? Constitution doesn't need to authorize the activity? I don't think so, you lying piece of crap. This is again the plain error of judicial legislation. As in all federal tax cases, the only beginning point of the subject matter jurisdiction of the trial court must begin with the required disclosure of the specific taxing power of the Constitution relied upon to bring the criminal charges or civil claims for tax. Without the full disclosure of the specific constitutional power to tax relied upon, i.e., impose duty or excise, to bring the criminal charges or civil claims for tax, there is no valid application at all of Title 18, Section 3231. As that statute has no application whatsoever with respect to individual defendants outside of the enforcement of indirect taxation. Section 3231 does not provide the subject matter jurisdiction to enforce a non-apportioned direct tax on income against individuals rather than the several states, as erroneously claimed by the Circuit Court, seditiously claimed by the Circuit Court. Finally, for the Circuit Court to opine on page 6 of its order and judgment that these constitutionally mandated limitations on the powers to tax are somehow inapposite within this case involving federal taxation is patently absurd, as the Constitution and its limitations apply to all federal tax cases in all federal courts without exception. Okay, that brings us up to issue 7, but I'm pretty sure we're going to get the end of the show commercial break coming up here in just a minute. So next week, we'll pick up again with issue 7. This is Thomas Freed on the Liberty Works Radio Network. We're reading from the petition to the Supreme Court to terminate the federal income tax. I'll be back next week with more on more. Thank you. Always fun. Bye-bye.